Hello, 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 friends. Hello, 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 Hello. Can't find whether it is you or not. Camera is in on. Hello. Hello. Hello, sir. Hello. Friends, is my audio clear? Yes. Okay. Friends, as part of today's video lecture series on India's largest education platform, Unacademy, today we'll be discussing the concept of plea bargaining. Okay, concept of plea bargaining. Friends, sections 265A to section 265L of CrPC are exclusively dealing with the concept of plea bargaining. Okay. Now, friends, before going to know about this one, let us see. If you want to compete with thousands of aspirants and stand out from the crowd, get Unacademy Judiciary subscription today. This is a regular pricing plan for Unacademy Judiciary Plus subscription, friends. 1 month, 3 months, 6 months, 12 months, 18 months, and 24 months plans are available. These are the regular prices. You can use my referral code SUBHANLIVE SUBHANLIVE in order to get 10% of offer. Apart from this, Unacademy Judiciary, on the occasion of its 6th birth anniversary, is offering a special price week which is valid from 9th December 2021 to 15th December 2021. Friends, 15th December 2021, that is today, is the last day for availing this offer. Coming to the special price of this special price week, friends, there are two kinds of subscriptions in Unacademy Judiciary: iconic subscription, they are iconic subscription, and plus subscriptions. These are the regular prices of iconic subscriptions. Now, in this special price week, Unacademy Judiciary is offering 15% of discount for iconic subscription as well as for plus subscription. These are the regular prices. Now there are these Unacademy Judiciary is not charging these regular prices. Only these special prices are charged with 15% discount. Friends, apart from this one, if you use my referral code SUBHANLIVE SUBHANLIVE, you will get additional 10% of offer in this special price. Thus, you can save nearly 25% of subscription amount if you subscribe Unacademy iconic or plus subscription today. Today is the last day. It is now or never. Avail this exciting offer, friends. This offer is given by Unacademy Judiciary on the occasion of Unacademy's 6th birth anniversary. Friends, let's crack judiciary services examinations together with Unacademy Judiciary. Friends, today's concept is plea bargaining. Plea bargaining. As we know that sections 265A to section 265L, these sections are exclusively dealing with the concept of plea bargaining. Now, the meaning of the word plea bargaining means it is a pre-trial negotiation between the accused and prosecution. Okay, it is a pre-trial negotiation. This negotiation is in between the accused person and the prosecution. Friends, the concept of plea bargaining was recommended by Law Commissions 142 and 154. Report of Law Commission, okay, 142 and 154 reports of Law Commission recommended several reforms in criminal judicial aid in the judicial system. As part of this one, the concept of plea bargaining was introduced into the Code of Criminal Procedure with a recommendation of Malayamat Committee. Friends, this was inserted through 2005 amendment. Through this Amendment Act, this was introduced. These sections, section 265A to 265L, have been inserted to the Code of Criminal Procedure. Friends, the major objective of the plea bargaining is to reduce the pendency of the criminal cases in the trial courts. This is the objective, and in case of non-serious crimes, the victims will get the victim compensation through victim compensation scheme. Now, through this one, through this plea bargaining, okay, in the offences which are punishable with imprisonment up to 7 years, can avail this opportunity. Through this one, the courts can easily reduce the burden or pendency of the criminal cases in therein. Sorry, now this is the object: reduce pendency of the cases. Friends, now let us see applicability of plea bargaining. Friends, the concept of plea bargaining is applicable to only the offences which are punishable up to 7 years. If the punishment, the offences which attract the punishment up to 7 years, for only for those offences, this one is applicable. The concept of plea bargaining is applicable. This is its applicability. Now, friends, the concept of plea bargaining is not applicable to several cases. The concept of plea bargaining is not applicable to socio-economic offences, and offences against women, and offences committed against children, offences committed by children under the 14 years. Therefore, this is the non-applicability of the concept of plea bargaining, friends. Here, in order to utilize this opportunity, that is plea bargaining, okay, Here, the accused person first he has to make an application. First, he has to make an application to the court. Who has to make this application? Here, the accused person has to make an application to the court, friends, to the court. Thereafter, after making of such application for plea bargaining, the court must see whether there is a pending trial in this case or not. Then this is the work of the court. Okay, this is the duty of the court. Whether the case is under trial or it is already trial is already over, this has to be looked into by the court. Therefore, friends, in the initial stage, I have said that plea bargaining is a pre-trial negotiation between the accused and the prosecution. Now, therefore, it is a pre-trial stage. If the trial is not yet commenced, then under those circumstances, an accused person must file an application to the court for plea bargaining. Then, along with this application must be accompanied by, okay, this must be accompanied by an affidavit. It must be accompanied by an affidavit. This must be sworn by the accused. Sworn by the accused person, friends. But along with this sworn affidavit or sworn statement, he must state that I am voluntarily preferring the plea bargaining in this case. This statement is mandatory. Okay, you must say that he has voluntarily preferred this application for plea bargaining. Okay, other persons for this application for plea bargaining before the honorable court. This is the first stage, that is filing the application is the first stage. Then along with in this one, he must state that he has not previously he has not previously not been convicted by court for the same offense. This point has also to be mentioned in this application. Okay, this application is made voluntarily. This is the first one. In his sworn statement or in his sworn affidavit, this is a mandatory term, friends. I am making this application, or I am preferring this application voluntarily. This is the one statement, mandatory. The second statement is, I have not previously convicted by the court in relation to the same offense. This has to be mentioned very clearly in his application. Then, friends, after a scrutiny of this application, the honorable court may issue a notice to the public prosecutor. It issues notice to the public prosecutor. This is the next stage in this one. Here, along with this application, along with a copy of complaint, Okay, a notice will be served to the public prosecutor. The court will serve this notice and fixes a particular date for hearing on this matter, for filing any objections from the side of public prosecutor, etc. Here the public prosecutor have any objections regarding this application filed by the accused for plea bargaining, he may submit or he may address his arguments in the fixed date. Okay, thereafter friends, thereafter on the fixed date, or the date which is fixed for hearing, on the fixed date the accused person shall be examined in camera. Therefore, in camera examination of the accused. After serving the notice, then both the parties will present on a date of hearing which is already fixed. On the date, in camera examination will be conducted. Okay, there will be an in camera examination of the accused, friends, to identify whether he filed the application voluntarily or not, is all his whether it is filed against his will, whether it is filed without his consent, whether it is filed due to some false promises or any threats or any coercion or undue influence. Such things may be revealed if an in-camera examination of the accused is conducted by the Honorable Court, wherein he has preferred an application for plea bargaining. Therefore, friends, in-camera examination of the accused is the next stage. Stage 1, preferring an application, then notice to the public prosecutor, then a date will be fixed. On the date, there will be an in-camera examination of the accused to know whether he has filed the application voluntarily or not. Therefore, it is used to test the voluntariness of the accused person. Thereafter, friends, after this one, if the court satisfies voluntariness, if the court satisfied with, if the court is satisfied about voluntariness of accused, hello, Pavitra ji. Good evening, friends. Do you have any doubts regarding this one? Okay, type your comments here. If the court is satisfied about the voluntariness of the accused person, then it must give sufficient time for the public prosecutor in case of it is initiated by the prosecution, or if the case is initiated by a complaint, then it must give some time for the complainant. Then the accused person and the complainant or the prosecution will work out a mutually satisfied disposition. Okay, then it gives sufficient time for, the court will give sufficient time for the prosecution or the complainant in case it is a complaint case, for mutually satisfactory deposition of the case. For mutually satisfactory disposition. Then, if both the accused person and the complainant or the prosecution mutually satisfied, including how much amount the accused is ready to pay towards compensation amount to the complainant or the victims, or the how much you want to pay towards the other expenses to the complainant, etc. This will decide the mutually satisfactory disposition, friends. Then the court will fix a further date for hearing. Then there will be a further hearing. Then the court will fix a date for further hearing. On the further hearing, if the court finds that the application has been filed by the accused involuntarily, this is the case of voluntariness. If the court is not satisfied about the voluntariness of the accused, if yes, if not, what is the remedy? If it is not satisfied that he is not voluntarily preferred this application, then under those circumstances, court shall proceed with the further matter in accordance with the provisions of the CrPC, friends. It is very clearly stated under section 265B of the Code of Criminal Procedure. Therefore, only the concept of plea bargaining is fully depends upon the satisfaction of the court. But there is no compulsion upon the accused person. There is no compulsion. Therefore, he must prefer an application for plea bargaining voluntarily, without any coercion or threat or false promise from any side. Once after preferring such application, the notice will be given to the public prosecutor and a date will be fixed for further hearing. On the date of hearing, an in-camera examination will be conducted for the accused in order to know whether he has preferred this application voluntarily or not. This will be elucidated on the date. If the court is satisfied about the voluntariness of the accused person, then the court will give sufficient time for both the parties, for the accused as well as for prosecution and complainant. If both the parties are mutually both the parties come to a mutually satisfactory disposition, then according to the terms, mutually satisfactory terms they have prepared with regard to the compensation amount, with regard to other damages, then the court will dispose of the case. If the court is not satisfied about the voluntariness of the accused, or if the court is not satisfied that the accused person was previously convicted by the court for the same offense, then the court may feel that he is a habitual offender. Therefore, plea bargaining cannot be entertained with regard to such accused person in those circumstances. Okay. Then the court will proceed in accordance with the Code of Criminal Procedure. Now, there is no plea bargaining under those circumstances, friends. No plea bargaining. No plea bargaining. Next, friends. That is very clearly stated under section 265B of CrPC. Now, friends, according to section 265C of CrPC, if both the parties or come or arrive at a mutually satisfactory disposition, if both the parties arrive at a mutually satisfactory disposition, then what will happen? If the case is instituted on the police report, then the court will give notice to, here the word court shall give notice to PP, public prosecutor. It must give notice to the public prosecutor, to the public officer who has instituted this report, and to the accused person, to the victim also. Therefore, the court shall give notice to all the persons if the accused person and the victim arrive a mutually satisfactory disposition with regard to the compensation amount, with regard to the damages, for recovery of damages, etc. Now, friends, they have to participate in a meeting in order to work out a mutually satisfactory disposition of the case. Here the court has to see that the entire process is voluntarily or it is made under compulsion. This will be checked by the court. If it is not, if the case is not instituted on a police report, if the case is reported on, if the case is instituted on a private complaint, under those circumstances, the victim and accused shall sit together. There is no necessity to giving notice to the PP. Therefore, the accused person and the victim, both of them can sit together and they can manage everything. Okay, they will work out for mutually satisfactory disposition, friends. They will work out a mutually satisfactory disposition with regard to the settlement of the case in plea bargaining in accordance with section 265C of CrPC. Here, if the accused person or the victim, if they want to, if they desire the presence of their counsels, then those mutually until they arrive mutually satisfactory disposition, the meetings will be held in the presence of their counsels, in the presence of their respective counsels, in the presence of the counsel for the accused, in the presence of the counsel for the victim. They can also present, they can also participate in the meeting, friends. Therefore, the plea bargaining involves an active negotiations, or it is active negotiation process by the accused person in anticipation of a lighter punishment. In anticipation of a lighter punishment, friends. First, the concept of plea bargaining was held in Blackledge versus Allison's case. Justice Porter Servett has used the concept of plea bargaining. Now, friends, now let us see the other part of this plea bargaining. This one. When the satisfactory disposition is worked out, that is when a satisfactory disposition is worked out, then the court shall prepare a report on the discussion. The court shall prepare a report of such disposition, and it shall be signed by the presiding officer of the court and other persons who have participated in the meeting. Therefore, this satisfactory disposition, this mutually satisfactory disposition is worked out. Then the presiding officer of the court, that means the judge, and the accused person and the victim in case of a private complaint case, and the PP, the police officer, the victim, and the accused person, all of them should affix their signatures in the report prepared by the court. Then friends, if no satisfactory disposition has been worked out, no satisfactory disposition is worked out, then under those circumstances, the court shall record, even though it is worked out or not worked out, it shall be recorded by way of a report, friends. The court has to hear the parties. Okay. The court shall record such observations also and proceed further as per the provisions of the code. It is very clearly stated under section 265D of CrPC. No satisfactory disposition. In this case also, the court has to prepare all the observations in its report. Friends, after preparing a report, if no satisfactory disposition is worked out, then the court will conduct a full-fledged trial in accordance with the provisions of Code of Criminal Procedure. So this is very clearly stated under section 265D of the Act. Now see these steps, friends. See 1, 2, 3, 4, 5. See all the steps. See all the steps. Then friends, according to section 265E of the Code of Criminal Procedure, when there is a mutually satisfactory disposition and a report is also prepared by the court, and all the parties to that one have affixed their signatures in the report, then the court has to hear the parties on quantum of sentence. Then after this one, according to section 265E, there will be a hearing on quantum of sentence. There will be a hearing on quantum of sentence, friends. Then the accused has to be released under section 360 of CrPC or by the provisions of the Probation of Offenders Act. There are two options available under Probation of Offenders Act. Here he has not convicted previously with regard to the same offence, therefore Probation of Offenders Act will also be applicable upon him. Therefore, according to Probation of Offenders Act or in accordance with section 360 of CrPC, after hearing on quantum of sentence, the accused person will be released either under section 360 of CrPC or under the provisions of the Probation of Offenders Act. It is very clearly stated under section 365E of Code of Criminal Procedure. Friends, if the court finds that minimum sentence has been provided under the law for the offence committed by the accused, it may sentence the accused to half of such minimum punishment. For instance, the accused person has committed an offence. That offence is punishable with minimum punishment of 1 year and a maximum punishment of 3 years. Now, This is the minimum punishment, friends. This is the maximum punishment. In the minimum punishment, 1/2, it means 6 months will be the punishment, friends. If the minimum sentence has been provided for an offense on which he was arrested and prosecuted, then the court may sentence the accused to half of such minimum punishment, half in this minimum punishment, but not on maximum punishment. This is half in minimum punishment. Therefore, minimum is 1 year imprisonment, half in one year is 6 months. 6 months imprisonment will be imposed on the person if he prefers an application for plea bargaining after giving the notice to all the parties, after hearing, after meeting, if they mutually if they come or if they arrive to a mutually satisfactory disposition, then on the further hearing the court may fix the quantum of sentence. If there is a minimum punishment for the offense on which he was charged and prosecuted, then in the minimum sentence he will be imposed half of such minimum. Therefore, for just assume that he was arrested for an offense for which he will be sentenced up to 1 year of minimum imprisonment and up to maximum 3 years. In the 1 year punishment, half will be 6 months. Therefore, 6 months punishment will be imposed upon the plea bargaining, friends. If no minimum period is no minimum period of punishment is provided for the offense, then the court may sentence the accused to 1/4 of the punishment provided for that offense. Okay, this is very clearly stated under section 265E of the Code of Criminal Procedure, friends. Thereafter, friends, after this one, the court will pronounce the judgment in the open court. Okay, after hearing on quantum of sentence, then the court will pronounce the judgment in the open court. Friends, and the same shall be signed by the presiding officer. It is very clearly stated under section 265F of the Act 1973. This is about step 1 to judgment, preferring application to the judgment. Now, friends, the judgment so delivered by the court shall be final and no appeal. Here, this is final one. This is final, and either the accused person or the complainant or the prosecution cannot challenge this one. No appeal is available. No appeal. No appeal lies, except the only remedy to challenge this judgment is special leave petition to the Honorable Supreme Court of India. This is the only remedy available to the person. Therefore, if this judgment is a final one, no appeal will lie against this judgment. The only remedy available to the either party to that case is special leave, to prefer a special leave petition before the Honorable Supreme Court of India. Under Article 136 of Indian Constitution, or by way of filing a writ petition under Article 226 and 227 of Indian Constitution, it is very clearly stated under section 265G of CrPC. Therefore, this is the importance of this one, friends. This is the importance of the concept of plea bargaining. Therefore, according to section 260 5H. According to this one, the court is vested with all the powers. If it wants to give bail to the accused person, it may grant the bail, and if it want to conduct the trial, it may conduct the trial. Therefore, the court shall have all the powers vested in respect of bails as well as trial of all the offences under this concept of plea bargaining. Therefore, friends, the period of detention undergone by the accused shall be set off. It is also very important concept. Already, if the accused person is was in detention, then this detention period will be set off. This detention period will be set off. For instance, the accused person is 2 months, he was in 2 months detention. Then under plea bargaining, the honorable court was passed 5 months of sentence. Okay, already he was in detention for 2 months. Therefore, 2 months may be set off, and remaining 3 months he may be punished with imprisonment only for 3 months. Okay, as per this illustration, friends, as per this example, but not in all the cases. But therefore, if the accused person was in the detention, that detention period will be set off, or it shall be, sorry, it will be not, it shall be set off against the sentence of imprisonment provided. Therefore, section 428 of CrPC is also applicable to him, friends. Thereafter, the provisions of this chapter, the concept of plea bargaining, is well enumerated under chapter 21A of CrPC. Therefore, these provisions shall remain, and this will prevail over anything stated under the other chapters of CrPC. It is very clearly stated under section 265J of the Act, friends. The statement of the facts are stated by the accused not to be used in any other purpose except for plea bargaining. It is also very clearly stated, if any admission has been given, if the accused person has voluntarily made any statements. Hello, Radha Rodaji. Good evening. Do you have any doubts regarding this subject? Okay. Therefore, friends, if he opens his mouth, if the accused person opens his mouth and he says something during the meetings conducted in between the victim or the complainant and the accused person, the police officer, sorry, the prosecution and the accused person, in those, what he has revealed in those meetings shall not be used against him. Therefore, this will be used only for plea bargaining. This shall not be used for any other purposes. This shall not be used for any other purposes during the course of trial. Therefore, it is very clearly stated under section 265K of the Act. Now, friends, nothing in this chapter applies to the juveniles or children under Juvenile Justice Act. It is very clearly stated under section 265L. This is about the concept of plea bargaining, friends. This is about the concept of plea bargaining. Now, let us see a few important judgments with regard to plea bargaining, the concept of plea bargaining. Okay, friends, the first one is that State of Gujarat versus Natwar Chanji Tagore. In this case, it was held that the very object of the plea bargaining is to provide speedy disposal of the cases and to reduce the pendency of the criminal cases. The object is very clearly stated in this one, in the state of Gujarat versus Natwar Chanji Thagore's case. In state of UP versus versus Chandrika. In this case, it was held that on the basis of plea bargaining, the court cannot dispose of the criminal cases. Therefore, it is very clearly stated in this case, friends. The third one is that state of Punjab versus Prem. In this case, it was held that plea bargaining is introduced for certain types of offences only, but not related to all the offences. Thus, this is about the concept of plea bargaining. Friends, I think we understood this concept through this class. Friends, Rodhaji and Nunna Pavitraji, do you have any doubts regarding the subject? Type your comments here and get your doubts resolved. Friends, let us have a recap about all the class within just 1 or 2 minutes. The plea bargaining is a pre-trial negotiation between the accused and the prosecution. The major objective of the plea bargaining is to reduce the pendency of the cases. It was introduced through 2005 amendment. Sections 265A to section 265L are exclusively related to plea bargaining. The concept of plea bargaining is enumerated under chapter 21 of CrPC. This is applicable to the offences which are punishable less than 7 years. These are not applicable to socio-economic offences and offences against women and children. Coming to the concept of plea bargaining, first the accused person shall prefer an application to the court for plea bargaining, but along with this application he has to file a sworn affidavit stating that he has voluntarily preferred this application and previously he has not been convicted for the same offence. These two are the essentials. Remaining content may be vary, but these two things have to be specifically stated in that application or in that sworn affidavit. Okay. Then after preferring this application, then a notice will be issued to the public prosecutor. After giving a notice to the public prosecutor, there will be a hearing on this application. Then on the date of hearing, the in-camera proceedings or in-camera examination will be conducted on the accused person in order to know whether he preferred this application voluntarily or not. Therefore, the test of voluntariness will be tested through in-camera examination of the accused on a specific date. If the court is satisfied about the voluntariness of the accused, then it will proceed in the matter in accordance with the other provisions enumerated under plea bargaining. If the court is not satisfied about the voluntariness of the accused, then the court will not go for plea bargaining and it will conduct the trial in accordance with the provisions of the Code of Criminal Procedure. Then the court will give the sufficient time for the prosecution and complainant for mutually satisfactory disposition. After that one, there will be a further hearing on whether they have arrived at a mutually satisfactory disposition or not. Then if the accused and the prosecution arrive at a mutually satisfactory disposition, if the case is instituted on a police report, then the mutually satisfactory disposition shall be signed by then a notice will be given to the public prosecutor, to the police officer, to the accused and victim. If the case is instituted on a private complaint, then notice will be given to the accused person and victim after they are arrived at a mutually satisfactory disposition. Thereafter, friends, when the satisfactory disposition is worked out, then the court shall prepare a report. If the satisfactory disposition is not worked in between the parties, then the observations shall be reported in the same report, and if it is not worked out, the trial will be conducted, friends. If the satisfactory disposition is worked out, then the court shall prepare a report. Then the court will fix a date for further hearing on quantum of sentence. Then the quantum of sentence will be imposed upon the accused person in accordance with section 360 of CrPC or in accordance with the provisions of Probation of Offenders Act. Coming to the quantum of sentence, if there is a minimum sentence is prescribed for that offence, then in the minimum punishment, half of the minimum punishment shall be treated as the punishment for the accused person who pleads the plea bargaining. If there is no punishment is prescribed, then after plea bargaining, the 1/4 of the punishment will be imposed upon the accused person. Then, friends, thereafter the court will pronounce the judgment in the open court. This judgment is a final one and no appeal is available. The accused person, either the accused person or the prosecution or the complainant, cannot prefer any appeal. The only remedy available is to prefer a special leave petition to the Honorable Supreme Court of India. That is the only remedy. Friends, it is further stated that if the accused person was previously in detention, the detention period shall be set off. For instance, before plea bargaining, he was under the detention for 2 months. Then the 2 months he was already in detention. Therefore, out of, if the court has imposed 5 months imprisonment, he was already in detention for 2 months, then the 2 months period will be set off. Only the remaining 3 months will be imposed as a sentence. Thus, that is the importance of plea bargaining. Then whatever the accused person has made in the plea bargaining shall not be used for other purposes. These sentences or these statements shall be used only for the plea bargaining. This is about today's class. Friends, these are the important classes we have discussed in this class. Friends, Unacademy Judiciary has been conducting free special classes every day by the top educators of the country. All the classes will be conducted on every topic of the law, like Indian Contract Act, Civil Procedure Code, Jurisprudence, Hindu law, Constitutional law, Criminal Procedure Code, Indian Evidence Act, Indian Penal Code, and all other local laws. Thereafter, friends, Unacademy Judiciary has been conducting expert guidance for Unacademy Judiciary aspirants. On July 7th, a batch has been commenced. On July 13th, one more batch has been commenced. On October 27th, on November 3rd, on November 17th, recently on 1st October, several batches have been started. Friends, from 15th December onwards, a new batch, that is from today onwards, a new batch will be commenced. You can join any of these batches. You can continue Unacademy Judiciary coaching, friends. Friends, apart from this, Unacademy Judiciary has started a Judiciary Iconic with the name of Judiciary Iconic. Unacademy Judiciary has been conducting the personalized mentorship, 1:1 live mentorship, live doubt solving, mains focused test series, and along with all benefits of the Plus subscription, friends. You can also use my referral code SUBHANLIVE SUBHANLIVE for 10% of offer in Iconic subscription amount. Friends, these are the features of special classes. This will be interactive live classes. There are chances for the learners to raise the hand. We never miss any classes. You will get notified for all the lessons and upcoming courses. You will get you can download the lecture notes. You will get access to recorded sessions of the live classes. You can revisit the important topics. You will have access to all the live classes at anywhere, from at any time, using your electronic gadgets. Friends, if you get the plus subscription, you will get all the access to the plus subscription. You will get India's best educators. You will have interactive live classes. You will have live tested quizzes. You will get structured courses and PDF notes. Friends, T20 mock test series on core subjects of judiciary is also conducted from Monday to Friday in between 9 a.m. to 9:30 a.m. on core subjects of judiciary, especially on IPC, CrPC, CPC, and Evidence Act. On every Friday, there will be mixed bag series. On every Saturday and Sunday at 7 p.m. to 8 p.m., there will be a detailed analysis of all these tests. Friends, apart from this, Unacademy Judiciary has started Unacademy Judiciary YouTube channel, wherein the live classes are being conducted. My live classes are also available on every Tuesday and Thursday at 9 p.m. onwards. Friends, you can join in Unacademy Telegram channel to know about all updates regarding upcoming classes and upcoming courses. Friends, stay tuned with Unacademy Judiciary. Thank you very much. Thank you very much. Let us start it.